couple was on board a minibus when it collided with a car in Mundoolan around 10:30 in the morning.
My head smashed into the chair, like the chair in front of me, and then next thing everyone was screaming and we were just trying to get off the bus.
19 people were taken to several hospitals, including a 23-year-old woman and 74-year-old bus driver critically injured.
That is the sound you might wince and stop to stare at, the newsreel it seems you see every day. All too often, a motor vehicle accident results in catastrophic injuries to multiple people. Motor vehicle accidents are one of the leading causes of life-changing injuries in Australia, with the Bureau of Infrastructure and Transport Research Economics reporting 39,000 hospitalisations from motor vehicle accidents in 2018 to 2019, and over 1,000 fatalities from 2020 to 2021. As stated by the Australian Institute of Health and Welfare, many crashes involve trauma to the head and neck. Because many of these injuries are severe and even lifelong, many of these victims often require compensation in the form of monetary support through either fault or no-fault schemes. Queensland's fault scheme allows the victim of any motor vehicle injury, whether a passenger, a pedestrian or another driver, to sue under the tort of negligence, so long as it was the fault of another road user. To make out a negligence claim, the plaintiff must prove that the defendant owed them a duty of care, that this was breached, that this was the cause of their injury, that no defences apply and that their injury requires compensation. Though duty of care is dealt with under the common law, a claim of negligence is mostly dealt with through Queensland's Civil Liability Act. Since all motorists must insure their vehicles under compulsory third-party insurance, referred to as the CTP scheme, as provided by Queensland's Motor Accident Insurance Act, damages are paid by the insurance companies. This allows for compensation at little cost to the individual at fault, making the amount of available compensation meaningful to plaintiffs, rather than placing an impossible economic burden on ordinary defendants who may even have suffered injuries themselves. Alternatively, no-fault compensation for motor vehicle accidents is available under Queensland's National Injury Insurance Scheme, NIISQ, through the National Injury Act, which provides lifetime support for those with acquired catastrophic injuries. This scheme as of yet only covers motor vehicle claims. While it compensates catastrophically injured victims through funding reasonable care and support, it does not compensate for general damages such as pain, suffering and economic loss as courts do through the CTP scheme. Though there is little issue with a negligence claim itself, the payment of lump sum damages, where damages are provided once and for all, can leave victims undercompensated and ineligible for Queensland's no-fault scheme through the NIISQ. While these fault and no-fault systems should remain distinctive, they should blend in the payment of damages to better compensate those in need. In any negligence claim, it must first be established that the defendant owed the plaintiff a duty of care. This principle can primarily be traced back to the 1932 case of Donoghue and Stevenson and its neighbourhood principle to contemplate and minimise foreseeable risks that could affect those closest to you. From this fledgling idea emerged established categories of duty of care, including that of road user to road user. Under cases such as Chapman and Hurst, Cook and Cook, and Embry and McNeely, all road users owe a duty of care to each other, fellow drivers, passengers, pedestrians, to contemplate and minimise risk to those likely to be affected by their actions. In practical terms, this means that a road user must be attentive to those around them, refraining from becoming distracted by technologies, or speeding, or driving erratically, or anything else that motorists are commonly wont to do that result in injuries to others. Though the scope of this duty relies on whether the risk to the plaintiff was foreseeable, in most cases this is not an issue and depends on whether the plaintiff belongs to a class of persons, such as a fellow road user, that could likely be affected by the defendant's actions. Because this duty extends specifically from road user to road user, liability is not indeterminate, which frees potential defendants from endless responsibility. Once the plaintiff has established a duty of care, they must prove that the defendant breached this duty. In contrast to Cook and Cook, which held that not all drivers owed the same standard of care to those around them, Embry and McNeely established that the standard of care to all road users is that of the objectively reasonable driver, no matter their level of experience. Under Section 9 of the Civil Liability Act, The plaintiff must prove that the defendant breached their duty because the risk was foreseeable, the risk was not insignificant, and that a reasonable person would have taken precautions to minimize such risks. Under this section and the common law, the probability and seriousness of the harm if care was not taken is typically balanced against the burden of taking minimizing precautions and the social utility of the activity itself. If the burden of taking precautions is too onerous on the defendant, failure to take such precautions does not amount to a breach of their standard of care. In the majority of motor vehicle cases, negligent actions, such as being distracted by technologies or other variables, will give rise to a claim against the defendant. All breaches are, however, determined on a case-by-case basis. This is advantageous as it allows for individual consideration of the responsibility owed to each plaintiff, though the burden of proving the breach always falls to the plaintiff on the balance of probabilities. Once breach has been established, the plaintiff must prove causation, that the defendant's breach was a material cause of the harm suffered. Under Section 11 of the Civil Liability Act, the breach must have been a necessary condition of the occurrence of the harm, factual causation, and it must be appropriate to extend the scope of the defendant's liability to the harm suffered by the plaintiff. Under the Act and case law which both predate and supersede its implementation, the test for factual causation is whether the plaintiff would likely have suffered the injury, either wholly or substantially, if not for the defendant's negligence. Under Section 11, the test for scope is whether the defendant could have reasonably foreseen that, or had control over whether, their actions would have extended to the plaintiff's general injuries. As stated in various case law, this examines whether the harm should be legally attributed to the defendant's actions instead of some intervening action by someone else. These tests are advantageous to the plaintiff because liability is not limited to only one defendant where multiple were involved in the plaintiff's injuries, so long as the plaintiff can prove that the defendant's negligence was a material cause of the harm. In most cases involving the negligence of road users, this can be established, even where a chain of careless drivers contributed to the plaintiff's injury. Each could be liable if their actions were a material cause of the harm and no intervening actions by others discharged their responsibility. Under Sections 6 and 7 of Queensland's Law Reform Act, one defendant can be sued for all the damage and acquire aid from other defendants in the chain of causation to compensate the plaintiff, meaning a plaintiff is not burdened by multiple negligence claims or only able to claim that part of the damages that they are entitled to. If a plaintiff establishes their claim, the defendant may prove that there was contributory negligence under Section 10 of Queensland's Law Reform Act. Under this section, damages are reduced to the extent that the plaintiff's own negligence contributed to their injuries. Because it used to be easier for plaintiffs to rebut a defence of contributory negligence, Section 23 of the Civil Liability Act and case law specify that the standard of care for the plaintiff is the same as the defendant, as that of the reasonable person, applying the same test as in Section 9 for a defendant's breach of duty against foreseeable risks. The defendant must also prove that the plaintiff's contributory negligence was a factual cause of their injuries, as a plaintiff would under Section 11. Though contributory negligence has yet to amount to a complete defence under Section 24, the court will apportion the plaintiff's damages depending on the severity of their departure from the standards of a reasonable person. While contributory negligence apportions blame in accordance with a fault-based system and substantially reduces a plaintiff's damages, this is largely dealt with by the National Injury and Civil Liability Acts. Under these acts, the NIIS can effectively pay the defendant's damages for care and treatment in place of their insurer if a plaintiff was less than 50% contributory negligent, with any reduction in damages discounted by the court. If a plaintiff in a motor vehicle accident suffers physical harm, they are entitled to damages. The purpose of monetary damages is to place the plaintiff back into the position they would have been if the harm had not occurred, though this is often difficult in calculating the expenses likely to be incurred in the future. Damages are often awarded in a lump sum, meaning that the money is paid all at once to the plaintiff. Damages are usually divided into categories. There are general non-pecuniary damages, awarded for physical harm that cannot be calculated precisely or which has no economic value, such as pain and suffering and the injuries themselves. There are also special pecuniary damages, which are awarded to cover medical and hospital expenses as well as calculable costs such as loss of earning capacity. These kinds of damages are subject to caps, such as a limit of 3 times the average weekly wage, and these damages are outlined in the Civil Liability Act from sections 50 to 60. The court can give an order for structured settlements where the defendant's insurance company pays the damages periodically, outlined by sections 63 to 67 of the Civil Liability Act. However, both the plaintiff and defendant must consent to structured payments. This is unlikely to occur if a claim has gone to trial. Traditionally, lump sum damages are paid under a once-and-for-all principle, meaning that neither party can appeal the court's order. Often this results in undercompensation to the plaintiff, as it is difficult to calculate the expenses plaintiff will acquire in the future, especially with economic inflation. While the courts are unconcerned with how plaintiffs spend their money from a lump sum award, they have no recourse to further compensation. Since structured settlements are rare because they must be consented to by both parties, the no-fault system of the NIIS must address this lack of compensation. While both damages and the NIIS, the NIS, fund treatment, care and support needs, only damages from a negligence claim compensate plaintiffs for the suffering caused by the injury itself and loss of earning capacity. This is why people may still wish to sue under the common law even with the no-fault scheme of the NIS, as they can receive wider retributive compensation through the defendant's insurer in line with the fault-finding theory of corrective justice. Currently, the NIS does not allow for re-entry if someone has received common law damages for treatment, care and support, regardless of the compensation's adequacy. While re-entry into the NIS after 5 years is theoretically possible, if plaintiff road users meet the standards prescribed by regulation, no regulation currently exists to permit this process. To replace the need for a regulation governing a re-entry process, the National Injury Act should receive an additional subsection 17A, making provision for re-entry into the NIS after at least 5 years if, after review, a plaintiff's common law damages are exhausted. This would allow plaintiff motorists who receive damages to obtain necessary care and funding through the NIS itself. Because this would only be possible if damages were exhausted and subject to independent review by the NIS itself. This would only be double-dipping the system where plaintiffs are truly undercompensated through a negligence claim, because necessary no-fault funding would relieve plaintiffs of pressure to avoid rehabilitation and exaggerate their injuries for better compensation through fear of reduced payments if their injuries appeared less severe. Independence and recovery would be encouraged in line with the theory of disability jurisprudence, while those at fault would still receive funding through the NIS. This reform would allow these fault and no-fault schemes to remain distinctive, while better compensating plaintiffs in need. Under the fault scheme of a negligence claim, all plaintiff motorists must prove that the defendant road user owed them a duty of care, that they breached their standard as a reasonable driver, and that this breach caused the plaintiff's injury. Subject to contributory negligence, plaintiffs will then receive monetary damages calculated by the severity of the harm and the expenses subsequently incurred. Though damages can offer plaintiffs wider compensation, lump sum payments often prove inadequate at predicting future expenses. While the no-fault scheme of the NIS provides motorists with funding for necessary care and treatment, no regulation exists allowing for the re-entry of participants who have received damages. This should be amended by the National Injury Act to permit, after a reasonable time and subject to independent assessment, the re-entry of motorists whose damages from a negligence claim have expired. This would encourage plaintiffs to seek independence and recovery instead of increased payments, because they will be able to fall back on the no-fault scheme of the NIS if damages awarded under the Civil Liability Act prove inadequate at compensating them for their harm.